If you're the victim of domestic abuse, what can the law do to keep you safe? In this video, I discuss non-molestation orders and occupation orders with Barrister Malvika Jaganmohan. Malvika, if someone is a victim of domestic abuse, what can the law do to keep them safe?
In the family courts, there are two types of order that victims of domestic abuse can try and obtain to keep themselves safe. One is called a non-molestation order, and that's exactly what it says on the tin. It's an order which seeks to protect the applicant from molestation. And that could be, for example, harassment, intimidation, threats of violence, physical abuse, verbal abuse, all sorts. The other type of order is called an occupation order. An occupation order can, for example, regulate the occupation of property, usually the family home. So it could say that party A can only enter these parts of the family home, party B can only enter these parts of the family home. At its most extreme, an occupation order can oust the respondent from the home altogether. So it has the potential to be a very, very draconian order because it interferes with someone's rights in their property.
Is one of those more popular or more common than the other?
In my experience, anecdotally, I'd say that courts tend to be more ready and willing to grant applications for non-molestation orders than applications for occupation orders. And I find that's particularly true at a without notice hearing. And by without notice hearing, what I mean is a hearing where the respondent doesn't know an application has been made and doesn't know that a hearing has been listed. So the hearing takes place in their absence, usually because the applicant says, I'm really scared about how they might react if they know I've made an application. Now, because at a without notice hearing, the court doesn't have the benefit of hearing from the respondent and doesn't have their side of the story, I find that courts tend to be very wary about making occupation orders at a without notice hearing because of the potential for it to be very draconian, particularly if there's the prospect of the respondent being kicked out of their home.
How should someone go about getting a non-molestation or an occupation order?
If you can afford legal advice, I'd urge you to seek legal advice. You may be eligible for legal aid. If you're not eligible for legal aid and you can't afford legal advice, you may be able to find a charity who can assist you with filling in the application form. The application form is called an FL401, and there are notes at the end of the application form which help you with the sorts of things that you need to be putting in the form. There's no fee for applying for a non-molestation order or an occupation order.
What should you put on the application form?
The application form is your opportunity to set out what exactly you're asking the court to do. So what kind of order are you seeking? Your application should be supported by evidence, usually a witness statement that sets out effectively your side of the story. What abuse do you say has been perpetrated by the respondent? If you're applying for an occupation order, the sorts of things that your witness statement will need to address are things like both parties' financial resources, both parties' housing needs, because those are the kind of factors that the court will need to take into account before making any order.
If someone doesn't want to go to court to seek a non-molestation order, are there any alternatives?
There are alternatives. I'd say they're more practical considerations than legal considerations. So if you need to keep yourself safe, you need to start thinking about alternative housing if you share a property with the person you say has perpetrated domestic abuse against you. So you may wish to contact local refuges, the local authority to try and obtain safe housing. You need to start thinking about financial resources. Is there a nest egg that you've built up so that you can safely leave, usually a partner? There are things that you need to take into consideration and there are actions you can take, but they're more practical issues rather than legal issues.
What's the biggest impediment to people seeking non-molestation orders?
In my experience, I find that applicants, if they are the victims of domestic abuse, are absolutely terrified about the prospect of being in court proceedings with the respondent, particularly if they don't have legal representation, either because they can't afford it, maybe they're not eligible for legal aid. It's an extremely scary prospect being in a courtroom with someone that the applicant is saying has perpetrated domestic abuse against them. So I find that that is often an impediment to victims of domestic abuse making applications.
What's the first thing you tell someone if they were a victim of domestic violence?
Tell someone. Tell a police officer, tell a social worker, seek legal advice, talk to a solicitor so they can explain their options to you. If you're the victim of domestic abuse, it can seem like a huge obstacle making yourself safe, removing yourself from that abusive relationship. So the first step is telling someone so they can help you to access the resources you need to be able to protect yourself.
Thank you to Malvika Jaganmohan from St Ives Chambers in Birmingham. If you enjoyed this video, please do subscribe. I also have a number of other explainer videos on family law. You can see a list of them here. This video might be one that you like, and this is my latest upload. Thank you so much for watching. Bye bye.